So just keep that in mind. And for our presenter today, we have Kirsten with the Labor.
Thanks, Kylie. So I'm Kirsten Small. I am an investigator here with the Department of Labor and Human Rights. Been here about 5 years now, a little over 5 years. I do a lot of the investigation, any sort of wage and hour complaints, human rights, so any discrimination complaints, as well as doing a lot of the presentations that we have, whether it be for things like fair housing or discrimination, or just our general hot topics presentation, which kind of covers all of the areas that we handle. Today, specifically, we are going to talk about fair housing laws with regards specifically to reasonable accommodations and modifications. We'll go in a little bit. So specifically, what exactly do fair housing laws? Obviously, our department handles discrimination based on protected categories. So we handle any discrimination complaint within the state that falls under our jurisdiction. The fair housing laws themselves that kind of govern what work we do state that they're basically laws, federal and state laws, that are put into effect to make it unlawful somebody differently in the sale or rental of housing because of that person's membership in a protected category. When we look at what those fair housing laws are, specifically we look at the Fair Housing Act of 1968, which is the federal side of things, as well as the North Dakota Housing Discrimination Act of 1999, and that's the state law. When we look at both of these laws, the Fair Housing Act of 1968 obviously is the federal side of things. HUD is the one that, Housing and Urban Development is the one that pretty much dictates and manages all of the laws and rules that are related to the Fair Housing Act. And then the Housing Discrimination Act, that is just the state level. When we look at both of these laws, North Dakota, we have a work sharing agreement with HUD, which basically means that instead of having two separate investigations go on, we can actually investigate cases for the federal side of things and vice versa. So basically, instead of, for example, if somebody felt that they were discriminated against on one of the protected categories, they could file with our department. If we did not have this work sharing agreement, they also could file with HUD, and then HUD would do their own investigation. We would do our own investigation. And, you know, the timeline wise, those may or may not kind of overlap, but it would mean that there would be two true separate investigations that would be going on. So obviously not usually ideal for most businesses or any landlords. And so kind of with this work sharing agreement, it allows for, again, us to investigate for the federal side of things as well as do our state investigation all at the same time. With this work sharing agreement, HUD, basically, they're kind of like our big brother. They can kind of review any of our findings. They keep track of where we're at with things. We have databases that are on the federal side of things that we kind of keep them updated to what the status of cases are. And then when we look at that kind of equivalency, when we have that partnership, we have to be substantially equivalent or pretty much on the same page as the federal laws. And so when we look at the North Dakota Housing Discrimination Act, a lot of the laws, the way that they're written, they are very similar to the federal side of things. And part of that is that substantial equivalency. With us having those similar laws, that's kind of what assists us in that work sharing agreement. Because if we had substantially different laws, obviously it would be hard for them under the same investigation. And so generally speaking, when you look at the North Dakota Fair Housing Act, the fair housing laws, they're going to be very similar to the federal fair housing laws. We do have, like I said, basically HUD can come in and review our findings for things. They do annual audits of our findings and our cases just to make sure that kind of everything is being handled fairly and we're following all of the laws and regulations with regards to the fair housing laws. So when we talk about being discriminated against based on a protected category, what are those protected categories? So the protected categories on the federal side of things is race, color, religion, national origin, sex, familial status, and disability. And then additionally, we do have some extra protections within the state. These are state-only protections. They're not covered under the federal side of things, but they can be addressed and made a decision on as far as whether or not discrimination occurred on the state level. And those additional ones are the receipt of public assistance, marital status, age, and then there's also a more recent one, 2015, we added the certain victims of domestic violence. When we look at age, it's going to be age 40 and over. And then just for the federal and state side of things, familial status, what that means is the presence of children under 18, somebody who's pregnant, or securing the custody of a minor. So basically, the individual that files with us has to allege discrimination based on one of categories in order to file a complaint with our department. So, you know, it could have been for a variety of reasons. It could have been because the landlord didn't like the color of their shoes, or, you know, the kind of clothes that they wore. Those aren't protected categories, so that's not going to be something that legally we have jurisdiction to look into. But if the individual alleges that they believe that they were discriminated against because of their religion, or because requested a reasonable accommodation and they believe denied in relation to their disability, then they can file with our department. So when we look at those protected categories, that's one of the main things we look at jurisdictionally, is whether or not the individual is alleging discrimination based on one of these protected categories. We'll just kind of go over just the stats a little bit. If you were on the call last week, we went through these same exact stats, but they basically just kind of the general housing claims. We do receive a number of, you know, a couple hundred cases each biennium related to discrimination. A small portion of that is housing claims. Basically, the majority of the discrimination cases that we see here at the department are related to employment discrimination, but we do see a decent chunk for housing, and then additionally for public service and public accommodation cases. And so with the housing claims for this last biennium, the 2017 to 2019 biennium, which would have ended June 31st of 2019, we had 58 total cases. 34 of them resulted in a conclusion that was a concern. 15 were no reasonable cause, which means that based on the facts and the evidence, we do not believe a violation of the law occurred. That they're just the facts, the evidence wasn't there to substantiate a violation of the law. One was reasonable cause. That means that based on the facts and the evidence, we have reasonable cause to believe a violation of the law occurred. One was dismissed. 5 were referred to HUD, and that could be per the request of the claimant, per the request of HUD. There could be a number of reasons as to why the federal department wanted to handle the case. And so sometimes just they are handling, let's say, 5 cases for that same exact landlord. They might just get the 6th one because they're already having an investigation currently going on with that landlord. And then 2 were withdrawn with resolution. A lot of cases we can have withdrawn with resolution or without. Generally speaking, a withdrawn with resolution means that they didn't necessarily share those details with us, but whatever the issue was resolved. Whether it was they had requested a reasonable accommodation and the landlord granted it, maybe there were some eviction proceedings and then they worked them out and were able to stay in, or maybe they just were looking for something like a positive rental reference or something of the sort. And so they were able to kind of take their case back, withdraw it from our investigation, and it was with a resolution. Said we had 58 total claims. That is down from the last biennium. We kind of see the ebbs and flows of cases, of all types of cases, and really depends on kind of the current climate, what's going on. The oil boom caused a huge influx of cases, and so we did have a number of cases during that time. Times when there's a high unemployment, sometimes that causes us to have higher cases. It just kind of ebbs and flows. We just have kind of a line that just goes up and down with regards to the cases. With the influx of cases that we had during the oil boom, a lot of that was a lot of individuals were coming to the state. And so we just had more individuals and a lot of individuals that were renting or they weren't necessarily purchasing property. And so there were more cases that were filed with our department. When we look kind of at the breakdown of what those 58 cases are, we had 4 of them were based on the basis of disability, 6 of them for retaliation, 4 were for public assistance, 4 for familial status, 3 for national origin, 3 for color, 1 for age, 2 sex, and 4 for race. As we talked about before, the ones that have the asterisk, public assistance and the age, those were state-only cases. As you look through these, you can see very obviously that there's considerably more cases than 58. That's because a lot of cases might be filed on multiple bases. And so if an individual believes that they've been discriminated against based on their disabilities, so for example, they requested a reasonable accommodation and they believe because they requested that reasonable accommodation, the landlord decided to take some sort of retaliatory action. So let's say they issued them some sort of written notice or written warning, and they believe it was because of the had requested that reasonable accommodation, that one might be filed on the basis of disability and retaliation. Another one that we see quite frequently is an individual that files on race may also file on color, national origin, and potentially some of the other categories as well. So each case can have multiple bases. And so that's why there's obviously more cases than there were actual cases filed, or there's more bases than cases filed. Of these cases, the 43 disability cases, 32 of those were for reasonable accommodation. So there's quite a need to discuss what reasonable accommodations are, what reasonable modifications are, because it is by far our most filed on issue, as well as disability being the most filed upon basis. So when we look at what is the definition of disability, we obviously have a legal standard that we look at. It's the most filed on basis by far, and so obviously discuss how we look at what a disability is will kind of help give some insight as to perhaps some of the individuals that people may be dealing with that fall under this act. Disability definition. So we look at the Fair Housing Act and our North Dakota State fair housing laws in regards to what the definition of a disability is. So basically what the law states is the individual must meet the definition under the law, and an individual who has a physical or mental impairment that substantially limits a major life activity, has a record or history of such impairment, or is regarded as with such impairment. And so when we look at these 3 different things, the first one would be more for something that's an active impairment, something that is currently substantially limiting a major life activity. The second one would be more they have a history of, it's not necessarily perhaps currently active. Maybe it's something like cancer could potentially be one. Maybe they previously had a history of bipolar, but they no longer are having any sort of flare-ups. They're not having any sort of conditions related to it, but the landlord believes that they might be. And then the third one is regarded as. So this would be the perceptions or the stereotypes of an individual having a disability, even though they don't have that disability. Probably the best example of that might be somebody who the landlord believes that they have some sort of mental disorder. They have maybe schizophrenia, and the individual, the tenant, does not have any sort of record or current impairment that's related to any sort of mental disability, and the landlord is treating them as such, or believes that they have it, so they're treating them differently based on that. And that's what that third one is as far as the regarded. When we look at what those physical or mental impairments are, there is not just a standard list There are a number of disabilities that, generally speaking, usually always fall under having some sort of impairment that substantially limits that major life activity. Things like some sort of visual or speech impairment, maybe autism, muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes. There's a number of, the list kind of goes on and on of ones that usually generally would fall under the category substantially limiting some sort of major life activity. But there is not just a standard list, so it really has to be kind of evaluated on a case-by-case basis. When we look at whether or not the individual is substantially limited, when it says that substantially limits a major life activity, at whether or not the limitation is significant or to a large degree. And so we do look at, to what degree does this limitation cause, or this impairment cause, some sort of limitation. And then when we look at major life activity, it could be a variety of different factors. It's activities that are central importance to daily life. So seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking. The list isn't exactly exhaustive. There, like I said, there is not a standard list for those items, but generally speaking, it's those things that we think that are those day-to-day functions in order for us to basically live. Talk about, like I said, some of those disabilities are fairly obvious. If an individual, has no legs and is unable to walk, well, it's pretty clear and obvious that they are a person with a disability, whereas other disabilities such as diabetes aren't necessarily going to be readily apparent from just us visually looking at an individual. So when we look at whether or not a person is a person with a disability, we really have to look at it on a case-by-case basis. And we, at the department, it can take everything from doctor's notes and documentation on that side of things to even just discussions with the individual, maybe witnesses, the landlord, to determine whether or not this individual was substantially limited. So a lot of people might think, well, it can only be discrimination if the person requesting has a disability, right? No. So when there's disability related items, so it might be harassment or any other category that an issue is falling under the basis of disability, it doesn't always have to be the individual themselves that has the disability. So it can be somebody that individual is associated with. Perhaps it is the child of one of the individuals that lives there has a disability, and they believe that they've been discriminated against based on that individual's disability. It could be somebody who's visiting the facility. If there's something or said that was discriminatory, they could always file again on the behalf of being associated with that person. And then lastly, things like discriminatory statements, things that are in advertisements, or maybe it's for memos or notices to the tenants. Just because the individual does not have a disability doesn't mean that they can't file on a discrimination charge based on disability. Another perfect example of that, written or verbal statements could be, or even nonverbal, it could be a testing kind of situation where a company may contact a landlord and ask some questions related to perhaps a reasonable accommodation, and the landlord, absolutely not, we're not going to provide any reasonable accommodations to anybody. We'll never, rent to somebody who has a disability. Again, not necessarily the person who has a disability is the one that's actually reporting the discrimination, but again, it could be a violation of the law. So we'll pause here for a second. I don't know if we have any questions, Kylie.
Not at this time.
Okay, perfect. So we'll just keep going then. So we'll move right into what exactly we're here to talk about today, the reasonable accommodations and modifications. So a reasonable accommodation, fair housing laws require reasonable accommodations for individuals with a disability, and failure to do so constitutes discrimination on the basis of the disability. Like I had stated earlier, this is by far the most common that we receive here at the department on the state level, and it is the most common on issue on the federal level. I believe the last time I checked their statistics, they had something, 60% of their cases were filed on the basis of some sort of disability related inquiry, and a majority of those were related to reasonable accommodations. The actual definition of a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So like I said previously, the whole intent of fair housing laws is to kind of level that playing field, to try to ensure that individuals aren't being treated differently on the basis of some sort of protected category. And so when we're looking at what these reasonable accommodations are, they're trying to eliminate barriers and issues that individuals with disabilities are having in the enjoyment of the rental or the space itself, whether that be within their actual, so within, for an example, their apartment, or in those public spaces. There's not exactly a list per se, but some of the common reasonable accommodations that we see might be related to, for an example, an individual with a disability has a lot of mobility impairment. They have a lot of trouble getting around, and even though the building has no assigned parking, that's always been the case, they don't have assigned parking, they don't have specific permitted spaces, the individual requests, for example, an assigned parking spot that's accessible for that individual entrance into their apartment. That could be a request for reasonable accommodation. Another one might be an individual that, again, maybe they have some sort of social disorder, or they have some sort of anxiety type disorder, and they don't feel comfortable leaving their home, or they have issues leaving the home. And the policy at the facility is to always, rent has to be manually taken into the rental office, or maintained at a drop box or something like that. The individual contacts the landlord and states, because of my disability, I have trouble doing that. Can I have a friend bring it in, or can I mail it in? Those might be requests to, as a reasonable accommodation. There's a request to modify some sort of practice or rule or policy that would assist the individual in having that equal and fair use and enjoyment of their space with regards to their disability. So when we look at reasonable modifications, these are very similar to reasonable accommodations, but they are slightly different. The reasonable accommodations, again, were more related to rules, policies, whereas the reasonable modifications, those are the actual structural changes that are made to a unit or the common areas for individuals with disabilities. When we look at, and we'll talk a little bit more about this on the next page here, but we do the same undue hardship that applies in the reasonable accommodations is what we handle with the reasonable modifications. It's any sort of structural change that is in order to afford such a person full enjoyment of the premises. It could be modifications to the interior or exterior of the facility. Some different examples could be widening of doorways, adding some sort of maybe grab bars in the bathroom, maybe a ramp to the exterior. It could be even small things like, just moving around the space in the kitchen, for example, or lowering a countertop, ensuring that there's a space under the sink so that an individual with a wheelchair can roll up completely to the sink. Things like that. Again, there's kind of limitless options of what reasonable modifications could be. But again, it's those structural changes. And some of the, generally speaking, when we look at reasonable modifications, and we'll kind of brush up on this again in a minute, but the reasonable modifications, generally speaking, the cost of the reasonable modification is going to be taken on by the tenant. There are some exceptions to that. So there basically, if based on when the facility was built, kind of when the construction occurred, the landlord may be liable for any of the costs that are there. If when the facility was built, it should have had those pieces to it already. So that the modification should have already existed. There shouldn't have really been an additional need to request that. In those situations, the landlord may be liable for having to pay for the modification, but generally speaking, a lot of the modifications are going to be on the tenant's behalf. They're going to be, the cost is going to fall on them. When we talk about, we had a question last week in regards to if the tenant leaves, what is the requirement for the removal of those modifications? And specifically, our law, as well as the federal law, states that any sort of interior modifications do have to be restored to the original condition, but exterior changes are not covered under that. They're not covered on the state law, and they're not covered on the federal law. So when it comes to any sort of removal of those modifications, specifically under the law, the only requirement is that those the interior pieces have to be restored to that original condition. Any of the exterior pieces do. So for example, a ramp does not have to be removed when the tenant leaves, because again, it's not covered under the law itself. So we'll go into a little bit about reasonable, and then we'll touch base on any other questions that we have. So when we look at what is reasonable, so we have two basic pieces to whether or not something's reasonable, and we have to look at whether or not it constitutes an undue hardship, and then it doesn't interfere with the business operations. So under the law itself, it states that it would impose undue financial and administrative burden when we look at that undue hardship piece, and then would making the accommodation require a fundamental alteration in the nature of the provider's operation. So even if one or both of these questions is yes, so it does constitute some sort of undue hardship, and it may alter the business operations, that doesn't technically relieve all obligations off the landlord, because they still may be required to provide some sort of alternative reasonable accommodation, really depending on the circumstance. And then when we look at whether or not these issues are, if it truly is an undue hardship, or if it interferes with that business operation, we look at these very closely. When we look specifically at the undue hardship piece, we look at the cost of the requested accommodation, the financial resources of the provider, the benefits that the accommodation would provide to the requester, and we look at that kind of in correlation with the individual's disability, and then the availability of an alternative accommodation that would effectively meet the requester's disability-related needs. So when we look at reasonable, and this goes for modifications or accommodations, the landlord may say, well, it's too much work. It's just not going to be feasible. We're not going to be able to do this. It's a burden to me. When you use that defense, it's going to have to be supported by your documentation. So, like I said, if we're looking at, well, it's too costly of an issue, or too many people are asking for it, the landlord really is going to have to come forth with the documentation indicating that it could not possibly have been done, and there was absolutely no other options that could have possibly been accommodations for these individuals. So when we look at what reasonable is, those are kind of some of the pieces that we are looking at in the landlord's defense. So we'll stop for a second here. Are there any questions yet?
Yes, there's a couple. If they knew where their designated spot was before they signed a lease, and now 3 days into living here wants a closer spot, is that reasonable?
Very much could be. Like I said, you'd have to look at whether or not It was a disability-related inquiry. And, you know, basically, if you're looking at whether or not it was reasonable, even if the individual knew exactly where their parking spot was before, you know, they signed the lease, they saw it, they were fine with it. Really, as a landlord, you would have to prove that by moving them to a different spot, it was just absolutely unrealistic. It was going to completely alter the nature of your business operations, or it was way too costly, burdensome, you know, couldn't possibly be done. And in the situation of a parking situation, it's pretty unlikely that would probably be something that would be proven to be some sort of undue hardship. And then when we look at, like I said, those alterations of your business operations, we're looking at an example of that might be an individual who has a physical disability that they're unable to walk. They request a landlord to drive them to the grocery store, to work, all of these things all around town. Well, that completely alters the nature of their business. That landlord has never provided that kind of service to any other individuals. It's completely altering the kind of structure they have. That might be an example of that business operations. But with regards to the parking spot, even if realistically you would think that, you know, the day, even if it was an hour before that they were assigned a certain parking spot, if they can show that it has some sort of tie to their disability and that they need the accommodation, or if it's a visually apparent, readily apparent to just an average person, then yes, you may very well be required to provide that reasonable accommodation.
Next question. If the modification raises the value of a unit, the owner have to pay too. For example, an automatic entry door.
I do not know the answer to that one on the top of my head. I do know I had provided the HUD link from their Accommodation and Modification, and I really want to say that was one of the questions that's addressed in there. So I will look back on that, and I will see if I can find an answer for it. And then I can at least email you out if you want to just provide your information, and then I can see if I can find an answer for that. I don't know it off the top of my head. I do think it was addressed in those reasonable modification documents. I'm not 100% sure, but I certainly will try to find an answer at the least, or point you in the right direction. It's a very good question.
That appears to be it for now.
Okay, perfect. So when we look at the disability-related inquiry, landlord asks for documentation. The short answer is basically law. It's fairly specific that the only time that an individual can request any sort of documentation is if the information is necessary to verify that the person meets the Act's definition of a disability, that it describes the needed modification, and 3, that shows the relationship between the person's disability and the need for the modification. Basically, if it is apparent, so the example of the individual who is in a wheelchair due to double leg amputation, that is a very readily apparent and visual disability. If the individual is asking for a closer parking spot or a handicap accessible unit, as a landlord, you're not going to be allowed to ask for further documentation from that individual on whether or not their disability is related to their request for that accommodation. Additionally, when you ask for that documentation, if the documentation that you receive states that the individual, you know, is an individual with a disability and the requested accommodation is kind of in conjunction with that disability, that it shows that need, the requested accommodation and the need for it is tied to that disability, that's really all that the landlord can ask for. Generally speaking, what we indicate to people is you don't want to act like the doctor in this situation. You don't want to continue to poke and prod and request additional documentation, request more and more access to medical records, anything like that. That can result in a violation of the law. Basically, you're not the doctor. If the documentation indicates it, even if you don't, believe that you're happy with it, that's what the requirement is under the law. One thing that our commissioners have always said, and even now, is when it comes to some of the requests for accommodations, things like that, sometimes it seems that it's more favorable to the tenant, sometimes it seems more favorable to the landlord. Kind of right now, we're on the pendulum that swings a little bit more towards the tenant. That may change. Laws always frequently change. Interpretations of law changes. But basically, as of right now, what the law is very clear on what that documentation, what you can and can't ask for. And so if the documentation is clear, that's really all request. Kind of that brief overview again of those accommodations versus modifications. The reasonable accommodation, again, that kind of alteration of change of policy, rules, or service. Generally speaking, the costs are going to be paid by the landlord, either in a private or a public setting. And then reasonable modifications, that's going to relate more to the removal of those physical barriers. And generally speaking, those costs are going to be paid by the tenant. In private situations specifically, a lot of times if it's a federally supported program, that's going to lie on the cost being paid by the landlord. But there's basically certain situations. One of the things that we look at with regards to any sort of reasonable accommodation or modification, one thing just to take into consideration, it doesn't necessarily apply in a lot of situations, but the Section 504 of the Rehabilitation Act, basically it applies in any situation in which a landlord receives financial assistance from any federal department or agency, and those landlords need to take steps as needed to ensure that existing houses are readily accessible and usable by persons with disabilities. Then ensures all new construction as well as any substantial alteration of housing are readily accessible and usable by persons with disabilities. And then it provides reasonable accommodations and modifications that require the housing authority to bear some of the costs as long as the costs do not amount to an undue financial and administrative burden. Again, that reasonable test, that undue hardship test that we look at. And then conduct needs assessment to determine whether the housing needs of a person with a disability are being met. Again, this isn't going to apply in all situations. It's very specific to certain programs that receive certain funding. One of the examples that they give is a public housing agency is covered by Section 504 in the operation of its Section 8 voucher program. However, a private landlord who accepts Section 8 tenant-based vouchers in a program for rent is not necessarily a recipient of federal financial assistance. It goes on to talk about some developers that receive some sort of grant or home funds for the rehabilitation of an owner-occupied unit is the recipient of, for purpose, Section 504. So they may be receiving federal grant funds with relation to the rehabilitation of the units. But that doesn't necessarily mean the individuals that occupy units or own those units doesn't necessarily make them beneficiaries of the funds. And so they don't fall, the owners themselves don't necessarily fall under Section 504. Again, very specific on what programs may or may not fall under the Section 504. If you receive some sort of federal funds, it might be something just to look into to see whether or not you do fall under this and whether or not basically you have kind of additional steps that you may need to take to ensure that individuals with disabilities have accessibility to all the housing and that their needs are being met with those housing. This is the one that always is quite a touchy subject with all landlords. I know you guys have a presentation on service animals, or you will be having one in general. It tends to be quite a hot topic. Again, when I talked about reasonable accommodations being by far the most filed on items, service animals and assistance animals definitely is probably at the top of those reasonable accommodations lists. We do have a lot of reasonable accommodations that are requested that are not related to service animals and assistance animals, but a good majority of the cases that we do see handle some sort of service animals or assistance animals. When you look at service and assistance animals, individuals that are disabled may require the use of a service animal or assistance animal. A disabled tenant may ask his or her landlord for reasonable accommodations in the no pets policy. And to deny the accommodation, the landlord must prove that such an accommodation is not reasonable, not necessary, or causes that undue burden on the landlord. A lot of times landlords get very upset, especially not necessarily as much on the service animal side of things, but the assistance animals or emotional support animals, things like that. When we look at whether or not an individual needs some sort of service animal or assistance animal, again, what we're looking at is whether or not the individual is a person with a disability, whether or not the requested disability is needed or the requested accommodation is needed for their disability. And if it's denied, again, whether or not it can be proven that the accommodation was not reasonable, it was not necessary, or causes an undue burden on the landlord. One of the things that we see oftentimes is landlords that may pose the direct threat defense. So they have concerns about the safety of other tenants, perhaps. Maybe they have concerns that the service animal may be, or the assistance animal may be aggressive. When it comes to any sort of direct threat defense, it has to be an individualized assessment, and it has to be made on the animal's actual conduct, not based on speculation or fear of the types of harm the animal may cause. It's basically that, and that goes for the harm or even damage. Basically, for landlords, you can't speculate or assume something bad might happen. It really has to be an individualized assessment that is based on, in fact, and the facts and evidence that you have has to support that if you take the defense that you believe that the individual or that the animal causes some sort of potential risk or direct threat to the other tenants. There may be a variety of types of assistance animals. It's not necessarily always a dog. It's not always necessarily a cat. That doesn't necessarily mean it doesn't qualify as being an assistance animal. Again, it looks very much on a case-by-case basis. And again, we look at whether or not the individual has a disability, and whether or not, based on that disability, there was the medical need to have the assistance animal. When we look at these for purposes, a lot of times landlords may say, well, can we charge some sort of the pet type fee so that there isn't sort of damage when they leave, things like that. HUD is pretty specific. They've provided guidance on several times that housing providers may not require persons with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. And one of the ways to look at it is, if you had an individual with a disability that was in a wheelchair, you would not charge them an extra fee. It wouldn't be lawful to charge them an extra fee to potentially cover any sort of damage that might occur from the use of that wheelchair. Same's going to go with the assistance animal or a service animal. They just actually, it's been quite a while that they had some notices concerning service animals and assistance animals from HUD in 2013, but they actually just released kind of a guide of sorts in January of 2020. I did provide that link, and basically it's kind of a step-by-step, if yes, go to this question, if to this question, and it kind of walks the landlords through the reasonable accommodation process, specifically related to service animals or assistance animals. And it can be a very useful tool if you maybe are new to getting any sort of request for accommodation related to a service animal or assistance animal, and it might be a way to kind of help streamline it and understand the process a little bit better. just recently, the last session, we did have a piece of the law go through on the state level that talks about service and assistance animals in a rental dwelling. Specifically, it states that a landlord require reliable supporting documentation be provided by a tenant of a rental dwelling subject to a no pets policy if the tenant asserts a disability requiring a service animal or assistance animal be allowed as an accommodation on the rented premises under any provision of law. And it goes on to talk about the reliable supporting documentation may be provided by a physician or medical professional who does not operate in the state solely to provide certification for service or assistance animals. Reliable supporting documentation must confirm the tenant's disability and the relationship between the tenant's disability and the need for the requested accommodation. A landlord may not require supporting documentation from a tenant if the tenant's disability or disability-related need for a service animal or assistance animal is readily apparent or already known to the landlord. We do get a lot of questions on what specifically reliable means, or the statement talking about that it's provided by a physician or a medical professional. What specifically that entails is something like a nurse practitioner or a psychiatrist. What exactly might fall under that? And realistically, when it comes to a lot of different laws, the way that things are worded, if it's not specifically outlined of what the definition of certain words might be. So in this case, reliable can be something that would be interpreted. And so when we look at a lot of those kind of laws, one of the things that's going to dictate how they're interpreted is just cases, what happens with cases going forward. And realistically, we have not had any cases specifically that have gone, as far up as things like the Supreme Court or things like that, that might give better guidance onto what specifically that interpretation of reliable means. So unfortunately, I can't provide a great explanation of what exactly reliable means. It's always going to be a case-by-case basis. But again, one of the things to keep in mind, again, you're not necessarily a doctor. You're not the person that, even though you may not necessarily agree with it, if the documentation is clear, showing the individual's disability and that the requested accommodation is related to that disability, legally that might be all that you can ask for. I do think, again, it's a fairly new law. As time goes on, I certainly foresee a lot of cases going even up as far as the Supreme Court to get a better interpretation of what specifically our interpretation of reliable is. When this law did go into effect, this was one that did cause some concern as far as whether or not this would make us substantially equivalent with the federal law, because the federal law is very clear that really any documentation from a provider could be considered as documentation that would be legally required to be assessed for a reasonable accommodation. And so the way it is worded right now, and currently we are still substantially equivalent, but this was one of the pieces of the law that definitely could have changed how any sort of cases were investigated within the state, because again, if we did not have that substantial equivalency, we would be investigating our cases separately from HUD and vice versa. So at the end of the day, if a tenant files a complaint, what exactly happens? What can you guys expect? Obviously, nobody wants a claim or complaint filed against them, but it happens. As I stated before, we had almost 60 cases in the last biennium. Statistically speaking, it's likely that you are hopefully doing things right and you're not going to have any sort of complaint filed. But as long as an individual files a complaint that has some sort of nexus between the harm and the discriminatory practice, they can file a complaint with the state. Again, they just have to allege some sort of discriminatory harm based on those protected categories and have that connection or that nexus between those things. When we receive any sort of complaint with the department, we receive the complaint usually in some sort of intake form. So a form that may have all of the events, everything that happened, and then we kind of condense that and summarize it down to what the actual alleged allegations are, what's actually being alleged as far as what the discriminatory practice was. And then that would be the actual charge itself that we would send out and request responses from the landlord. When it comes to any sort of investigation, we are a neutral third party. All we do is take the facts and the evidence and make a decision on whether or not a violation of the law occurred. We aren't on the tenant's behalf. We're not on the landlord's behalf. We, again, are just a neutral third party that's just investigating the complaint to see whether or not a violation of the law occurred. Once we go through the complaint, we do the actual investigation, and then we determine, again, whether or not reasonable cause exists that or violation or not of a violation of the laws. And we do that through the facts, the evidence, the documentation, any sort of interviews by both parties and maybe even by other tenants. And then again, we come to a conclusion basically at the end. Throughout the whole process, we do offer conciliation, or basically try to kind of informally resolve the issues between the parties without having to go through the entirety of the investigation. It's voluntary. It's up to either party if they want to participate in that. But if we're unable to conciliate it or come to some sort of resolution, then a determination is what we issue, and that's kind of our final report explaining exactly how we came to our conclusion and what the facts are that led up to that decision. So it goes over every piece of the case and why or why not we believe a violation of the law occurred. So lastly, how do you guys know what not to do? Obviously, the first one, know the law, and if you don't, visit with an attorney that's knowledgeable in fair housing law. The I didn't know defense isn't a valid defense. Just because you didn't necessarily know the speed limit, you still might get pulled over for speeding. That's kind of how it goes. As a landlord, it is your obligation to know what laws apply to you in certain situations. So for example, if you do fall under any of the fair housing laws, it's the obligation of that landlord to know what the fair housing laws are and to ensure discrimination isn't occurring. One big thing is train your managers and staff, especially the staff that works with the public. If you're going to have any staff member that's going to be taking calls from the public or you know, discussing things with tenants, you're going to want to make sure that they're well trained so that they know what could be considered discrimination and things that are the ways to handle things or not. When it comes to, again, reasonable accommodations, that rash, sudden decision of absolutely no, not, that sounds silly, we're not going to do that, you know, that might cause problems. That might not necessarily be the best practice, because you may be having a discriminatory act whether or not you intended to. A great example, again, if an individual contacts you over the telephone, for example, and states, well, I have 6 service animals, I want them all living with me, and you as the landlord goes, absolutely not, we are not going to do that, we would never allow that here. That potentially could be a problem. You know, you can certainly say, well, we have a practice as far as how we handle any reasonable accommodations. We would just need to have documentation related to the need for the accommodation, things like that. You know, having that consistent process and having your staff trained on how to handle the situation can really prevent a lot of issues from happening. Again, be consistent. If you are being consistent from tenant to tenant, you're going to run into a lot less issues. If you're always consistent and professionally in your answers, it really is going to prevent a lot of issues from coming up. Next, document things. In a day and age where everything really is easily documented, whether it be text messages, emails, you know, everything can be documented fairly easily, and really you should take advantage of that. In the case that a case is ever filed against you, the documentation will be key in helping you explain exactly what your position is, show the documentation behind what your decision was, and it really will help streamline the process, not only for you, but just, again, it will also help lend to that consistency piece that you always know this is the same way that we do it for everyone, you have the documentation backing that up. And then lastly, visit our department website. We do have information about the housing laws. We have some brochures, and then HUD's website. I know it's obviously not everybody's most favorite thing to do, myself included. It's not like we usually sit down and read for 6 or 7 hours legal language, because it tends to get kind of messy, and it's very wordy, and it's hard to follow. HUD actually has put together, between their joint statements and some of their guidance, they actually have a lot of great resources that are in really user-friendly formats, question and answer type formats. They give examples of situations, so it really can help landlords understand what the laws are in a bit more of a user-friendly way. It's not that you have to necessarily sit down all at one time and read it, but even if you just take a couple minutes each week to review them, make sure you're staying up to date on what those fair housing laws are, it really will help you in the long run. So that's all I had for you guys today. Are there any questions right away? And if not, you guys could certainly shoot them out to me by email, but we can go through any questions now too.
I do have a couple. So back to the parking spot, I would have to give this person another tenant spot, and they don't have to give me any paperwork. They can just ask, and I have to switch their spot with another tenant.
Well, you'd have to, I mean, you may have to follow whatever the reasonable accommodation process that you have, and depending on that individual's disability, you know, if it's readily apparent, yes, you may have to. It's going to have to be based on that specific situation. Really, I can't give you a yes or no answer. I mean, without having absolutely every single fact and doing an investigation, we can't provide any sort of advice or guidance on those things. But generally speaking, you would have to just follow whatever your reasonable accommodation process is. But if the individual is somebody who the disability is readily apparent and the need for the accommodation is readily apparent, you may not be allowed to ask for more documentation, but you're just really going to have to look at it on a case-by-case basis.
I have a double amputee in my building, and she has a motor scooter. Is it a reasonable accommodation or modification to give her a way out of the building that does not put her in the middle of ambulatory individuals trying to get out? For example, a spring lock on her ground floor balcony so she can get out in case of fire or emergency.
Again, I can't provide a yes or no answer on that situation. It really has to depend. I mean, basically what you have to look at is, you know, again, is the reasonable accommodation that's being requested, is it tied to the person's disability? Is it needed to have the full enjoyment and basically use of the facility or the unit? And, you know, if it is, you know, if providing that would cause some sort of undue hardship, you have to look at whether or not that actually does. If you believe it's going to cause some sort of undue hardship or problem, you would have to assess very specifically financially what that looks like, and have all of your factors to why you believe that it's an issue for an undue hardship. In those kind of situations, and even the previous one, really, if you're really not sure how to handle it or what to do, again, that's a great piece to contact an attorney that is familiar with fair housing laws, because even though I completely understand it, I know it's frustrating. I used to work in the safety realm and had to contact the Department of Transportation all the time, and I found it quite frustrating because unfortunately we can't provide any sort of guidance as far as we can't provide legal opinions, we can't provide advice, we can't provide a policy or something that basically gives you an answer to whether or not the violation of law occurred or things like that. We can't provide those things. All we can provide you is basically what the law is, but the interpretation itself has to come from you. And again, I completely understand the frustration behind that, but unfortunately that's all that we really can provide, because of the fact that, again, we're just a legal agency. We can't provide any sort of legal opinions or guidance. statutorily we are not allowed to.
If the tenant is denied under the Century Code and it goes to the Supreme Court, can the tenant keep the assistance animal until a final decision is made?
That I do not 100% know the answer of that. I believe they would, because unless we found, I'll be honest, generally speaking, a lot of times people file with us after they are no longer living there. So I can't say that we have a lot of situations where the individual is still living in the unit and believes that, and files, just generally speaking. I don't know, but I can certainly check on that and get you an answer. The top of my head, I believe that they would have to, unless the employer or the landlord shows that it's some sort of undue hardship in the meantime.
And then one more. What can be done when you think the letter for an emotional support animal is from the internet?
I guess I can't provide you an answer to that because again, it's going to fall under that the landlord is going to have to prove that the documentation is invalid in some way, you know, whether that's on the basis of that Century Code piece or whatever the case may be. You know, you can't, again, you are not necessarily the doctor, so you can't just interpret those things. And if you want to interpret those things, you just know that you may have to deal with the potential ramifications of if they file with us. And again, if it kind of moves up in the case, if it is that we don't believe, or we believe that a violation occurred, and that they want to pursue the issue through court, you know, that's basically what would have to be done. But otherwise, I can't really provide a yes or no answer as to what to do in that situation, because of the fact that it really just depends on what makes you think that. What is the documentation? Is it showing the individual's need and their disability, things like that? You'd have to kind of assess it again on that case-by-case basis.
Okay, how would the parking spot question even be legal? So the other tenant who has a signed lease and pays for a spot has to give up said spot for the accommodation. Wouldn't the other tenant have some legal stance on that issue?
Again, it's just going to be a super case-by-case basis, because you know, there's no requirement under the law that you have to force another tenant to give up their spot. Same with potentially, like if they were in a unit that one individual specifically wants versus the other, they have to show that need for the accommodation, that the accommodation is needed, that, for example, the parking space is closer to the entrance or something like that. And it may come down to you as a landlord may have to find another accommodation that works just as well. And whether that be talking to that individual that has the parking spot and trying to have them switch with the person, or finding another parking spot that would be a viable option, potentially could be the way that you would have to handle it. But just because it doesn't seem like it's realistic or reasonable, it doesn't necessarily, you still have an obligation to find an accommodation that is effective, in the fact that it reduces or eliminates whatever that kind of barrier is for the individual. But again, one of the biggest things with that parking spot is you're going to have to assess whether or not the individual, again, whether or not they're a person with a disability, whether or not that request for the parking spot is related to their disability or needed for their disability. And if they have documentation of that, then again, you may have to, as a landlord, assess what your potential options are. They don't necessarily have to be exactly specifically what they requested, but it has to be effective.
And then kind of to tie on to the assistant animal, the internet is not a medical provider. How are we to accept that when it needs to be a medical provider?
again, it's going to be a case-by-case basis. I know I keep saying that, but it really is. It depends on, you know, who is providing that, because especially right now in the day and age of this pandemic, where a lot of things, they may have telehealth where they're having doctor's visits with doctors over the internet. So just because it's an internet note per se does not discount it or discredit it as being a provider. You're really going to have to look at it on a case-by-case basis. And again, you know, if you have valid documentation that you believe it's inaccurate, or that it is not a true relationship to the individual's disability, then you can take action based on that. But again, if the individual files a complaint, just know that may be something you will have to prove or provide documentation of. You can't just say, well, I didn't think it was real. That's not going to be a good defense. You know, you may have to provide, I didn't think it was real because of X, Y, Z. You may have to provide your side of things as to what happened. I'm not saying all reasonable accommodation. I mean, every single doctor's note that ever exists, that just because it is a doctor's note, you have to take it hook, line, and sinker. Again, the requirements is that it shows the individual as a person with a disability. It shows the need for the accommodation related to that disability, and that they're tied together. That's what the documentation really has to prove. Just, again, be mindful because of the fact that, again, right now, telehealth is going to be something that we're going to see a lot more of. And so online documentation, just because it came from online, doesn't automatically discount it as being, or discredit it as being false. It's not necessarily always going to be the case. You're going to want to look very, very much on a case-by-case basis.
All right, last question. If a rental property responds that we don't accept Section 8, is that discrimination based on receipt of public assistance?
It could be, yes. It definitely could fall under the category of the public assistance discrimination, which again is a state-only piece.
That seems to be the end of them. End of questions.
If you guys have any other questions, you guys can feel free to reach out to us. Like I said, this is just the general department's website and documentation as far as the email address and telephone number. Again, we don't want to make you guys hate us for not being able to always provide answers, because again, we just have that major limitation of we can't provide a yes or no answer because we may not have all of the facts, and we are not able to provide any sort of legal opinions, things like that. And I know, again, it's quite frustrating, but at least we can hopefully point you in the right direction. Our whole intention, honestly, is never to just have everybody stay in the dark so nobody's doing it right. Really, if we had a perfect world, all of the landlords would be doing it the right way in the first place, and we wouldn't have any cases. So it's certainly not our intention to keep people in the dark. We do try to point you at least in the right direction, but we still are limited on whether or not we can provide, you know, really specific answers. And again, it's going to really depend a lot on the specifics of that actual case. And sometimes the only way to determine whether or not it was done right is to do an investigation, and that's once a complaint is filed. So it's not something to be scared of, because again, if a complaint is filed, it happens. We see them quite frequently. And even if it is we do find a violation of the law, it's a perfect learning example. I mean, it's something that you guys can take forward and move forward from, and know that how to do it the right way going forward.
All right. Well, thank you everybody for attending. Again, just remember you don't have to register again for the upcoming trainings. You're already on the mass email list, so there's no need to register again. And also, you don't need to let us know which sessions you are attending. So just a couple things to remember. And thank you, Kirsten, for presenting 2 weeks in a row. And for the rest of you, we'll hopefully see you next week. Thank you.
Thanks, guys.
Thanks, Kirsten.